first matter to come before us this morning is State of Ohio versus John W. Edvon. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal, so for the appellant, wish to reserve some time, if you let me know when get started on keeping the clock. You can also reference it on the wall over there. Our arguments are being recorded and they will be posted on the court's YouTube channel, so please stay on the podium and keep your voices up. Please do not use the names of minors or victims. As I just said, it's going to be posted on the YouTube channel. The judges have read your briefs. We're ready to proceed when you are.
Thank you. Good morning, Your Honors.
Morning.
Attorney Edward Fidel on behalf of the appellant John Edvon. And this is my first opportunity to appear in front of this court, and I'm honored to have made my appearance here today. I'd like to reserve 5 minutes on behalf of the appellant.
Certainly.
Thank you, Your Honors. May it please the court. 2953.08G allows for the appellate review of the findings related to 2929.13, 2929.14, and other statutes, Your Honor. Most applicable to the criminal statutes would be 2929.13 and 2929.14, as that's what's most commonly seen in front of the trial court and the appellate courts. The evolution of Edvon and his progeny determined that the findings on the record are appropriate to preserve appellate review in the consecutive sentences findings. And I would argue, as you've seen through the brief, that to allow otherwise in the context of sentences related to an otherwise mandatory probation under 2929.13b1 would nullify the court's opportunity to review the record appropriately and the findings made by the trial court. And I understand that other jurisdictions have found that there are no findings required. I also respect the Foster lineage and how we've eliminated the court's fact-finding necessity and findings on the record, and that as long as the court indicates that it has found that the principles and purposes of sentencing have been considered, the factors of recidivism and otherwise have been found, is sufficient. But I would argue that that analysis is misguided as it relates to this exact situation. 2929.13b is a situation where individuals similarly situated as Mr. Edvon, with no prior felonies, non-violent felony as a first offense, no prior violent offense as a misdemeanor, are given the opportunity to have a probationary sentence.
Counsel, how do we know that your client does not have any prior felonies or prior misdemeanors?
Through the record, through PSIs, through.
Do we have the PSI in the record here?
PSI was not, I don't believe it was submitted with the appellate record, Your Honor.
Because I don't think there's anything really on the, at the hearing, the sentencing hearing that talks about his prior record per se.
I believe that would be correct, yes. Yeah, I don't believe I think the majority of the debate was, he didn't show up and why didn't you show up? And then it just ended with a sentence. And that's exactly what I think we're all trying to avoid going forward on these types of matters, where individuals are being deprived of their freedom without the adequate due process to address the findings and preserve for proper appellate analysis. We all went through that when the consecutive sentences and Edvon came out, and this statute, 2929.53g, enumerates that findings are necessary for appellate review of 2929.13b. And to simply read 2929.13b in isolation, it does not specifically state findings. It doesn't, as opposed to 2929.14 for consecutive. I'll acknowledge that. But it has to be read in conjunction with 2929.53g, where it allows the court to review the findings of the trial court, not the conversations or the record or the analysis. It's the findings. And I think without reading those two statutes together would deprive the defendant his due process rights of losing the opportunity and the privilege of probation when the law sets forth a sentencing structure that, essentially demands it unless certain exceptions are made. And in this situation specifically, I would say the presumption of probation was significantly higher than other circumstances because the child support statute specifically enumerates that probation is the preferred sentence in those situations because of the need to get back to work, to have a structured environment, and to begin to make those child support payments that they were deficient on, and then make those payments going forward. To deprive a defendant of the right to analyze the court's findings, I think deprives them of proper safeguards when you're removing them from the community. This was not an individual that had a prior violent past, had no prior felonies. And in this case, it's not even clear if the judge found that he did violate a condition of bond. The appellee in this case noted in the brief that there were 2 separate capiases issued. One capias I would argue, if there was a finding here, would not be sufficient to violate a condition of the bond. It was the pre-trial, it was the indictment, the summons was sent out to a bad address, never received, failure to appear. That would not be considered a condition of bond violation. The other situation, while the case was pending, yes, a capias was issued. I'm not going to argue against that. But what was done subsequent to that was that he self-disclosed to the police as soon as he knew he missed court. If I'm not mistaken, there was a domestic incident between his roommate and the girlfriend, so the police were called out to the apartment, and he immediately self-disclosed to that officer. They contacted, they ran him through leads, there was no warrant in the system, and he pressed the issue and said, no, I have a warrant. I believe it's in the record, they ended up contacting the court and confirming the warrant that way, took him into custody and immediately brought him back to Medina County to be held accountable. If the court found that he had violated a condition of the bond, then the court would conceivably have the opportunity to review that finding and whether it was supported by clear and convincing evidence.
Well, obviously, he didn't make anything, he didn't do a written finding in the journal entry, but a review of the hearing clearly demonstrates that he didn't buy his excuse, and he said several times to him, I let you out on bond, and this is what you do to me, basically.
Right.
So it's very clear as to why he thought prison was appropriate.
Correct, and that's similar to the analysis of the other cases, quite frankly, that were cited by the appellant. I appreciate that. But that too was the argument that was set forth before Bunnell was set. And then Bunnell came about providing the same appellate review structure that's in place and provided defendants the safeguards that are appropriate, that the court must make those findings on the record to preserve those rights to be reviewed on appeal. Absent that, we have a situation where the court doesn't have to put its findings, doesn't have to put reasons on the record under Foster, and then we have a statutory construction situation here where the review is for findings. It specifically states in 29-29-53G that the court has the ability to review the findings as it relates to 29-29-13B. If we're not requiring the trial courts to make those findings, then what exactly is the Court of Appeals reviewing? And I would argue that its authority is nullified if the trial court is not required to make those findings. The case law and the lineages certainly says the Court of Appeals can't substitute. I appreciate that, and I recognize that. And again, trial courts don't have to put reasons on the record. So what happens if there isn't any reasons? He comes into court, has a sentencing hearing, and he's sent to prison. Okay? But the record, certainly the docket would show that there was a capias issued. I would argue that situation is no different than having a conversation on the record, absent the court making the appropriate findings, and then held accountable through the Court of Appeals and whether those findings are supported by clear and convincing evidence. And I would ask that the court agree and remand it back to the trial court to review the appropriate findings and determine if they can be satisfied. Thank you.
Thank you, counsel.
Morning, Your Honors, and may it please the Court, I'm Vince Vellucci with the Medina County Prosecutor's Office on behalf of the appellee, the state of Ohio. Mr. Edvon argues that the trial court erred in sentencing him to 12 months in prison. He cites 29-29-13B1A specifically, which says that first it generally states, I should say, that first-time nonviolent felony offenders with 4th or 5th degree felonies cannot be sent to prison. However, there are multiple exceptions that are then immediately thereafter set out in section B1B, where trial courts do have the discretion to send that type of offender to prison. Mr. Edvon clearly met one of those in this case because he violated the terms of his bond when he failed to appear for his trial on August 8th, 2022. Mr. Edvon argues that there had to be some kind of findings made to overcome the presumption of community control. No Ohio appellate court has held that trial courts have to make any kinds of specific findings on the applicability of any of the B1B exceptions. In fact, multiple Ohio appellate courts have actually held the exact opposite. That trial courts are not required to make specific factual findings when imposing a prison sentence under 292913 B1B. In my brief, I cite cases from the 1st, 3rd, 5th, 7th, 8th, and 11th districts, all holding that. In any event, there's a lengthy, on-the-record colloquy that I quote in my brief that makes it very clear, as Judge Carr noted, that at Mr. Edvon's change of plea and then at his sentencing hearing, the trial court was understandably focused on and not at all happy about Mr. Edvon's failure to appear at his trial. Not only did Mr. Edvon fail to appear at the trial, he had to be extradited back to Medina County from South Carolina at great expense. Additionally, it was noted on the record that Mr. Edvon had to be extradited at the beginning of his case when he failed to appear on his summons. And I think that was taken into consideration as well, rightly so. So he actually had 2 failures to appear in this case, Your Honors. At sentencing, I would add that the state of Ohio read into the record a very compelling victim impact statement as well from the mother of Mr. Edvon's unsupported child. And I'm sure the trial court took that into account as well. And I believe this court should also. Mr. Edvon, in addition, made almost no child support payments before or during the pendency of this case. That's another thing that came up on the record at sentencing, and I'm sure was also taken into account. It should have been taken into account, Your Honors. The standard, again, is that was the sentence clearly and convincingly unsupported by the record or contrary to law under Markham? We do not have that here. In fact, a review of the record reveals that for several reasons that I just mentioned, including the failure to appear at the trial, Mr. Edvon's sentence is very much supported by the record in this case, and it's not contrary to law. It is within the statutory range.
Counsel, let me interrupt you for a second. I know this is not the situation that's here, but because it is pretty clear, I think, from the transcript record that the court was very, very, very upset with the fact that he didn't show up for trial. And obviously violating the court's bond conditions, but on top of that, 50 other people showed up for trial, for jurors and so forth, and he wasn't there. So an argument could be made that we are able to review why the trial court sentenced him to prison in this particular case because of that colloquy or because of that discussion. However, I guess my concern is, what about if there weren't a situation where that was on the record and there's nothing in the journal entry other than has considered the principles of sentencing? How is an appellate court to review that sentence when it's clear the legislature has in fact said very clearly that it wants 4th and 5th degree felony conviction felons to serve a community controlled sentence?
And I think in 95% of the cases, they won't be sentencing people to prison on those. And there usually is some kind of extenuating circumstance, I would say, like this, where someone didn't appear for trial, and typically you're going to have that on the record. But I can see a scenario that you mentioned, like where there would be nothing on the record, but I think that simply isn't the law, and several appellate courts have said that you don't have to make those specific findings, and the general assumption is that the court has considered the principles and purposes of sentencing, the recidivism factors in 29, 29, 11, 12, and that same standard applies here. It is presumed, unless the record shows otherwise, that what's happening in 29, 29, 13, B1A and B1B, it's presumed that the trial court considered that unless the record shows otherwise. So I think the presumption, the strong presumption would still be to uphold the sentence, even if it was relatively silent, as you're saying, or completely silent. The presumption is that statute was considered, unless there is some evidence on the record, I think otherwise. So it's kind of the same way that point 11 and point 12, I think point 13 in that respect would be viewed the same way. And I think it also is a good point that when you look at the record, we don't know that necessarily that this is his first felony either. So
Counsel, I guess, in reviewing this, I guess, maybe it could be argued it's a little bit different because the statute specifically says you shall, and there's a presumption. That's not necessarily present in all the other statutes.
well, I think they have to be, all of these statutes say that, 29, 29, 11, and 12 is a shall that the trial court has to consider as well, and it's presumed that the court considered that, unless it's stated otherwise. That's been well established, and I think this is the same idea here. The idea with the consecutive sentencing, that's kind of an outlier in terms of having to actually enumerate findings on the record, and that is very specific to that situation, and that makes sense. That's an extraordinary thing to do, to impose consecutive sentences. So yes, B1B, I don't think it is necessary here, but you have an extensive record showing exactly why the trial court did what it did, and it's not just the failure to appear at trial either, Your Honors. There is all of these other things as well, I think. The failure to make the payments, what happened at the beginning of the case and not appearing, the victim impact statement, which I think was compelling.
But none of those factors are listed by statute.
Correct, yes, but I think when you consider those with on top of the not appearing, which clearly falls under the statute, that leads you to believe that I think the maximum sentence here, that the 12-month sentence, becomes far more reasonable, and it is more reasonable, and frankly warranted in this case. So if there are no other questions, I would respectfully ask this court to affirm the judgment of the trial court. Thank you.
Thank you, Counselor. You will have the full 5 minutes for rebuttal.
Thank you. Thank you, Your Honors. Addressing the issue related to no courts have found what I'm requesting. I think that is first of all, that is accurate, but I also think that's a narrow analysis reviewing those cases. Those courts specifically look to the plain language of 29-29-13B, in that they don't see the word finding in there. And I think that's an inappropriate way or not really a helpful way of analyzing the situation, because it has to be read in conjunction with 2953.08 that gives this court the appellate review. And in that situation, it specifically enumerates the findings that are to be reviewed, similar to 29-29-14, where that statute specifically states findings. maybe it was a mistake of statutory construction, legislative intent, but if the Court of Appeals has the ability to review findings, but yet the trial court is not required to make findings, then what exactly is the Court of Appeals' job to review? Okay? And so I would ask that the court consider that and read those two statutes together, along with 29-29-14, which has already been significantly scrutinized over the last decade, I would say, in that the court is required to make findings and put those findings in the record, in the journal entry, that gives notice to the offender, that gives notice to the Court of Appeals on why you are now sentencing somebody to a consecutive sentence. And I would not minimize a sentence in this situation as the state has, where that's an outlier or a significant situation. Having someone who has lived their entire life in the community as a generally law-abiding citizen to now be removed from their family, their job, their kids, and deprived of their freedom and sent to prison, whether it's 3 days, 30 days, 6 months, 9 months, the state of Ohio has presented an extra layer of protection for those individuals that they have to determine to be non-violent or non-necessary prison sentences. Everyone has the protections of 29-29-11 and 29-29-12, the principles and purposes of sentencing and the recidivism and mitigating factors. And we all have that. And what the state is arguing here is considerations that the court must have made to send them to prison, to send Mr. Edvon to prison, whether it be the victim impact statement or the failure to pay while he was on, while the case was pending. Those would relate to that bucket. But Mr. Edvon and similar situated defendants have the extra layer of protection of 29-29-13 that essentially states you can't send these people to prison unless this applies. And that's the issue here that we're looking to overcome, similar to consecutive sentences. The law is everyone is presumed to have concurrent sentences unless you find otherwise. And those safeguards are in place to protect judges or protect defendants and protect judges from the emotional aspect of these cases and to protect defendants from losing their freedom for a significant period of time, which is what we want. We want those protections. We want those safeguards. And all I'm asking is that same analysis is what applies to this situation. Those two statutes are enumerated in 29-29-53G for a reason. And I ask that they be treated the same and that defendants have those appropriate safeguards in place. It's not presumed that the judge covered it. 29-29-53G requires that the court, I would indicate, put those findings on the record. Maybe he did, maybe he didn't. We don't know. We know we talked about it, but was that the reason why Mr. Edvon went to prison? We need to know that. The court needs to find that. There was a conversation, there was a back and forth, and you can certainly see that the judge was getting upset and just ended the hearing. It was a conversation about not being there, and then all of a sudden it just ended. 12 months in prison. A maximum sentence when two statutes are in play here, saying probation, probation, probation. And I think to find otherwise would deprive defendants a significant right that the court is not required to make those findings before they send someone to prison, if those factors are met. And that's all I'm asking. Thank you, Your Honors. I ask that you vacate the main further findings. If there aren't any other questions, I'll rest.
Thank you. Thank you both for your presentations today. And thank you both also for coming to Akron for oral argument today. The court will take the matter under advisement. We will issue a decision in due course, which will be sent to all parties to its appeal, as well as posted on the Hot Supreme Court website. Thank you.
Thank you, Your Honor.
Thank you.